Okay. I hear a car in the background. I think that's on your end.
Good afternoon, everyone. Welcome to everyone who is joining us for today's webinar. People are still logging in and we'll get started in just a moment. Good afternoon, everyone. Welcome to everyone who has just joined us for today's presentation. People are still logging in and we will get started in just a moment.
I could have shared a picture of where I was yesterday.
Okay, good afternoon, everyone. Welcome to this week's edition of JewishGen Talks. We are pleased to be here together with Randy Schoenberg, who will be talking to us today about privacy and genealogy. What are the rules? Randy is someone who needs no introduction, especially within the Jewish genealogy world. He is a board member of JewishGen. He is the director of Austro-Czech research at JewishGen, and many of you will know him from the movie A Woman in Gold that was made about a very famous case that he was able to work on. And he is also the author of The Beginner's Guide to Austrian Jewish Genealogy and Getting Started with Czech Jewish Genealogy. And he has become an expert on this particular topic of privacy and genealogy. A couple of notes about how today's webinar will be structured. Randy will speak for about 50 minutes or so, 55 minutes. If you have any questions, please post them in the chat and we will do our best to get to them at the end. Many of the questions will probably be covered during Randy's presentation, but if they're not, please post them on the chat and we will try to get to them before it's over. If we are unable to get to all your questions, we will be sending out a survey following the presentation and there will be an opportunity for you to ask any additional questions. So without any further ado, Randy Schoenberg.
Hello, everyone. I'm here today in Mammoth Lakes, California, which is about 6 hours north of Los Angeles, and very happy to be able to do this webinar. It's a little unusual doing something like this without a live audience, and I have three teenage to young adult kids in the background who may be wandering around. We also had a 6.1 earthquake about 100 miles south of us just an hour and a half ago. So anyway, if there are any challenges to this, I hope you'll be understanding. This is a lecture based on a talk I gave already 5 years ago at the IAJGS conference in Jerusalem, Israel, and that I've given several times since then and tried to adapt. What I'd like to do actually is go through the prepared talk, maybe a little too much reading, but to give you an idea of the legal landscape and what the rules actually are. And then when we get to the end, we'll answer some questions. I think there were at least 15 questions that came in before the talk and that I've written out, and hopefully we'll be able to get those answered and have more of a discussion, or at least a one-way discussion if other people aren't allowed to participate on this platform. So without further ado, let's look at privacy issues with online trees. By the way, this lecture that I gave, you could also probably find online. I think it's published on Avotenu online. If you search for privacy issues with online trees, you should be able to find it and you can look at it with all the footnotes and details, some of which I will skip in this presentation. Okay, so let's get started. Let's hope this PowerPoint works. There we go. The right to privacy is actually a relatively recent concept and relatively new to the law, and it's one that is still evolving today. As genealogists, people whose goal it is to learn and write about personal details of other people, we often hear complaints about invasion of privacy. So it's worth exploring the issue in some detail to understand what rights exist at the present time and what might evolve in the future. So much of our work is done online, so I'll address privacy issues related to online trees and various online platforms. So some history first. Although Judge Cooley in his 1988 treatise on torts had argued for a, quote, right to be let alone, prior to 1890, no English or American court had ever expressly granted relief based on any right of privacy. However, in 1890, Louis Brandeis, who you can see here as my sixth cousin twice removed, he was a Kentucky-born lawyer, but working in Boston with Jewish roots in Bohemia. And he later, of course, became the first Jewish Supreme Court Justice in the United States. Brandeis penned a Harvard Law Review article on privacy with and at the urging of his friend and colleague Samuel Warren. Here's Samuel Warren's family tree, in case you care. In The Right to Privacy, Brandeis and Warren argued that the legal principle of a right to privacy should be acknowledged under the law. The impetus for the article, which is considered by most people to be the most influential law review article ever written, I'm not exaggerating, the impetus might strike us today as a little quaint. Warren, who in 1883 had married the daughter of US Senator, Secretary of State, and one-time presidential candidate Thomas Bayard, was concerned primarily with gossip columns. And here's a section of the article to give you an idea. The press is overstepping in every direction the obvious bounds of propriety and decency. Gossip is no longer the resource of the idle and of the vicious, but has become a trade which is pursued with industry as well as effrontery. You can read it as I go on. But they were really concerned with gossip columns. And no one is really quite sure why. Scholars have speculated on what might have so irked Warren to write this and get his friend Brandeis to write this article. In 2007, Professor Amy Gaida published an article analyzing the press coverage of Warren and his family. And thanks to his father-in-law Bayard's political prominence, Warren and his wife had been frequently mentioned in society reports describing family weddings, funerals, and parties. Although the coverage was quite tame from today's perspective, the family was no doubt a bit sensitive when in 1889, so 1 year before the article, and 3 years after the death of Mrs. Warren's mother, the newspapers reported that her 60-year-old father was to remarry a woman, shockingly, 20 years his junior. The newspapers had earlier reported on Mrs. Warren's friendship with President Grover Cleveland's 21-year-old bride, Frances Folsom, whom the bachelor president had married not long after the press had disclosed the existence of Cleveland's illegitimate child from a prior affair with Maria Halpin. But perhaps the prurient gossip was just imagined, as nothing salacious has yet been discovered that would justify the outpouring of anti-press rhetoric contained in the Brandeis-Warren article. Nevertheless, the article, The Right to Privacy, led to the development of 4 related but very distinct categories of privacy rights, which were delineated by University of California, Berkeley School of Law Dean William Prosser in his 1960 article, which is really a seminal article called Privacy. And here are the 4 different areas of protection. So the first is appropriation of name, voice, or likeness. And that was the first right that was really adopted by the courts. It's really a right against appropriation of a name and likeness for commercial purposes. The right limits the ability of advertisers to use the name, face, and voice of a celebrity or others in films or advertisements without permission. The category could also come under the rubric of false advertising, since the purpose is to prevent misleading suggestions of celebrity endorsements, as well as protecting the right of celebrities to profit off their own fame by endorsing products. The second right of privacy is against intrusion. This bars physical intrusion, searches, eavesdropping, wiretapping, and hidden sound and video recording. This aspect of privacy requires an affirmative act of prying or intrusion that a reasonable person would consider objectionable, and the thing intruded upon must in fact be private. For example, it's not an intrusion to watch, follow, or even photograph a person walking on a public street, although it would be to use a selfie stick to film up a woman's skirt, for example. So that's the right against intrusion. The third right is for public disclosure of private facts, and that's going to be the one that we're going to focus on. A cause of action can be brought for objectionable publicity given to private information, even if true. A 1931 case involved the revelation of the present identity of a former prostitute who had been a defendant in a murder trial 7 years earlier. Other early cases involved publication of a person's debts. The facts must be private facts, not generally known to the public, that are offensive or objectionable to a reasonable person of ordinary sensibilities. And lastly, the fourth area is false light in the public eye. In these cases, the invasion of privacy is a result of attributing to the person some generally embarrassing or objectionable attribute that he doesn't hold. For example, if one were to take a picture of a random person and place it in an article on syphilis sufferers, this would be considered an invasion of the person's privacy. This category is perhaps quite similar to the law of defamation, since it applies only to false and misleading attributions. There are, of course, limitations and defenses for invasion of privacy actions, most notably the common law privilege and in the United States constitutional right to report on and discuss public figures and events of public interest in the press. For public figures such as politicians and celebrities, there is no invasion of privacy unless there is a finding of malice, which is to say an intentionally false and misleading publication of a private matter designed to harm the subject and not for the legitimate purpose of parody, opinion, or public comment. I've gone into this great detail in order to demonstrate that mostly what we call the right to privacy has little or nothing to do with what we do as genealogists. Certainly the first and last categories, appropriation and false light, have no possible connection to genealogy, since we are not in the business of using people's names for commercial advertisements or films, nor do we intentionally add false facts to our family trees in order to embarrass people. Intrusion also would not ordinarily be an issue of concern unless you're in the habit of using unorthodox methods of obtaining genealogical data. For example, I suppose hacking into private adoption files might give rise to a cause of action. But barring something egregious like that, the only possible category that could concern what we do when we build family trees is the one pertaining to public disclosure of private facts. Before we delve further into the right against public disclosure of private facts, I want to suggest that in my opinion, this is my personal opinion, this category is ripe for reevaluation. The old cases that first give rise to the concept increasingly seem old-fashioned and out of date. What we often do when we limit disclosure of private facts that ordinary people deem offensive and objectionable is perpetuate stigmas. Promiscuity, homosexuality, illegitimacy, infidelity, etc. were long considered so objectionable that the mere mention of the fact, even if true, was considered offensive and an affront to public morals. By limiting disclosure and discussion of these facts, the stigma was reinforced. Their absence from the public sphere made their occurrence seem more rare and unusual than they in fact were. Yet the considerable change in public opinion on these issues and others has demonstrably been the result of more disclosure and discussion. For example, the controversial practice in the 1970s of publicly outing prominent homosexuals under the protection of the reporting privilege no doubt has led to the great advances for the homosexual community that we have seen in the past decades. Disclosure can lead to the erosion of the very stigma that makes the fact objectionable. By making the presumed behavior, somewhat deviant behavior, at least presumed by the public, more apparent and even ubiquitous, and therefore less threatening, we eliminate the stigma. We need to be cognizant of this when we consider the rights of individuals to prohibit public disclosure of private facts based on the current state of public mores. Protecting privacy in some cases reinforces the need for privacy by affirming the stigma attached to an otherwise unobjectionable fact. Now, this is not to say that there is no need for any privacy. The law already delineates a number of areas where privacy is protected and disclosure cannot be compelled. For example, the attorney-client privilege protects the conversations between a lawyer and her client so as to foster a more open and trusting dialogue, without the fear that an admission made to an attorney can be used later for a prosecution. Similarly, the law protects what you say to your doctor, and by extension, the results of medical tests. Conversations between married spouses or priest and penitent can also be privileged from disclosure under the law. The same applies, for better or worse, to tax returns. Turning now, however, to genealogical data, however, the existence of legal protections are much less than clear. Are there, in fact, any limits on what we can and cannot be publishing on our family trees. Let's look at the basic rules. Let's first attempt to differentiate between living and deceased people. Do the deceased actually have any privacy rights? And if so, how are they protected? Since dead people cannot assert rights for themselves, this question is related to the question of whether privacy rights can be asserted by heirs on behalf of someone who is deceased. With regard to the right against misappropriation of likeness, the common law did not extend to heirs any rights to assert a claim. So this is the first type of privacy right. In one California case, the heirs of the actor Bela Lugosi claimed profits from Universal Studios for exploitation of Lugosi's Count Dracula character. But the Supreme Court of California denied the claim, finding the heirs had no common law right to prevent the use of Lugosi's likeness. California subsequently passed a law giving heirs rights against appropriation of the celebrity's name or likeness for 70 years after death, almost like a copyright. Other states have enacted similar protections. However, no statute has extended such inherited rights to claims for public disclosure of private facts, which, as I demonstrated above, is the only aspect of the right of privacy that would pertain to genealogy. Therefore, absent new legislation, there is no right of privacy issue with regard to disclosing facts about deceased individuals. This means that as far as the law is concerned, genealogists should feel free to disclose genealogical data and even embarrassing facts about the deceased. No legal claim can result from such disclosures. With regard to the living, the rule against public disclosure of private facts applies. The facts privileged from disclosure must be private facts, not generally known to the public. They're offensive or objectionable to a reasonable person of ordinary sensibilities. Regular genealogical data regarding name, date and location of birth, marriage and death, the names of parents, siblings, spouses, and children should seldom give rise to any claim for invasion of privacy, since these facts are usually not private, but are known by a wide range of people, and further are not offensive or objectionable to a reasonable person. As Dean Prosser explained in 1960, quote, "No one is entitled to complain when there is publication of his recorded date of birth or his marriage," end quote. With regard to some embarrassing private facts, however, the genealogist is probably wise to tread with caution. If it is not generally known that the milkman was your cousin's father, it's probably not wise to publish this fact. By extension into the modern world of DNA testing, disclosing that a father does not share the Y-DNA haplogroup of his putative son could in fact be problematic. This is not to suggest that liability will result from the disclosure of any such facts. There may be defenses in any particular case, and the existence of damages from an objectionable disclosure might be uncertain and may depend on how many people will have seen the disclosure. Remember that the test is not whether the supersensitive subject objects, but whether a reasonable, ordinary person would find the disclosure objectionable. Even the milkman example might not rise to this level, especially if the publication was for the purposes of a family tree. There are today not many genealogical facts that the ordinary person might find truly objectionable if disclosed. Adoption, homosexual relationships, out-of-wedlock births, and even gender transitions may now be safe to disclose as the stigma previously applied to these facts has receded. By contrast, the public disclosure that a birth was the result of rape or incest might still be thought sufficiently objectionable and may give rise to a potential for liability. A genealogist should use his or her best judgment in these cases, but there really is no hard and fast rule to rely on. I want to repeat again that the objection of the individual concerned is not relevant to the legal question, so long as the fact itself is neither private nor objectionable to an ordinary, reasonable person. Genealogists commonly hear complaints from people who fear the disclosure of their birth date or mother's maiden name, often because of an irrational fear of so-called identity theft. The truth is that what is commonly called identity theft is in reality just garden variety fraud, and it is accomplished without the use of genealogical data. The most prevalent type is the result of theft of credit card data from merchants. The thief steals the credit card information, usually in bulk from a computer file, and uses it to make purchases. No family tree information is used. The other type of identity theft is when someone applies for credit in your name. This type of fraud is perpetrated ordinarily by a bank teller or someone in your home who already has access to your mail phone, address, date of birth, and social security number. Again, no search for genealogical data is ever involved. As far as I've been able to determine, there's not been even one documented case of identity theft involving a family tree. Not one. I've given this lecture now for over 5 years, and no one has ever come up with a counterexample. So again, to return to the question, an individual's irrational fear of identity theft should not give rise to any claim for violation of the right of privacy against a genealogist, because an ordinary, reasonable person should not have any such fears, as the true risk of any damage or embarrassment is 0. This means that as genealogists and those who are committed to public genealogy, we should feel free sometimes to ignore the objections of those with irrational fears about the disclosure of commonplace genealogical facts. At least from a legal perspective, we have every right to disclose those facts. They are neither truly private, nor are they objectionable or damaging. Private facts do not include information that has been voluntarily disclosed to a third party or knowingly exposed to the public. Many people know your date of birth. Think of all those birth announcements and everyone who has ever celebrated your birthday. Your mother's maiden name is also known to a wide range of people, namely everyone who ever knew her, or at least prior to her marriage, or who also knew her parents. These facts may be published because they are not private in any sense of the word. Compare them to the truly private conversations protected by the attorney-client, doctor-patient, spousal, or priest-penitent privileges. You cannot make an otherwise public fact private merely by wanting it to be private. As a result, with few exceptions, ordinary genealogical data may be published without giving rise to any potential claim for invasion of privacy. So far, I've been focusing on American rules, but what about the new push for a right to be forgotten, or right of erasure in the European Union and elsewhere? Jan Meisels-Allen has been following the worldwide developments closely on behalf of the IAJGS Public Records Access Monitoring Committee. And if you're interested in this issue, you have to subscribe to her mailing list because you'll get regular updates. There are many facets to this development, and it would probably be better if they were being dealt with separately, but instead, Europe seems to have enacted broad regulations that could have, in some sense, very serious consequences for genealogists. I just read there's a recent case in the last month where a grandmother was ruled to be wrong in putting a picture of her grandson on her Facebook page, and the court threatened to fine her if she refused to remove it because she had a falling out with her daughter, and the daughter complained that her own mother had no right to put a picture of her grandchildren on her Facebook page. So these are sort of the low-level rulings that are coming out now in Europe. I'm not sure they'll hold up as the cases go up, if they do. But it is a different regime now that they have in Europe than we have in the United States. In the United States, the line between public and private actors is more defined, I think, than in the more socialized European Union. And this has led to some of the confusion. On the one hand, there is a concern for government data collection. Disclosure of mass data collection and snooping on foreign officials by the NSA have raised privacy concerns in the United States and abroad. In the United States, these concerns are focused mostly on government collection of data, restricting both the collection of data and the ability of individuals to access the data that is collected by the government. There's no serious discussion in the United States of limiting the ability of private companies and individuals to collect and use data. Americans are more committed, I think, to free speech and free enterprise, and bristle at the idea that the government could hold a monopoly on big data or use it to invade privacy. We're less concerned with abuses by individuals than we are in protecting our freedom from government intrusion and restraint. As a result, our privacy laws are directed at limiting government and protecting property, as in the Fourth Amendment right against unreasonable searches and seizures. Americans tend to be less concerned with what private corporations and individuals do with data that is collected, as that would infringe individual liberty and property rights. By contrast, in the European Union, where the government generally is much more involved in people's lives and often owns stock in large corporations, the idea that governments should be restricted more than private corporate or individual actors seems almost not to have been considered. Europeans appear not at all concerned with a potential government monopoly on information, but are apparently very concerned that their neighbors and large corporations might be collecting data. I'll just give you one example. In Germany, the law requires every individual to register his address with the authorities when he moves to a new home. The ability of the police, oops, am I still on there? Because I don't see my picture. The ability of the police to know the whereabouts of every individual and to register his address with the authorities is just considered a fact of life without any concern for privacy. However, no such law has been passed or could be passed, I think, in the United States. So it is in Europe that we see an increase in data protection laws designed to allow ubiquitous data collection by the government, but prevent private individuals from accessing even relatively ancient records for fear that someone might learn something the government already knows. Now, I'm not seeing my picture here, and I'm a little concerned with that. If I can stop for a second.
Yeah, I see you, Randy.
You see me? Okay, so I will continue without looking at myself. That's fine. I hope everybody's okay.
Yeah, people on the chat are writing in that they see you just fine.
Okay, so I would argue that European focus on limiting private access to data while allowing widespread government data collection is misguided. Again, this is my view. If European history of the past 100 or so years teaches us anything, it's that the danger lies in abuse of governmental power and the failure to allow private actors to balance that power. Rules that give the government a monopoly on information and data collection, I think, should be adopted very cautiously. Let me turn then, though, to a development here in the United States, and that is the California Consumer Privacy Act. This is a new act which goes into effect, I think, in full on July 1st of this year, so in a week. It was passed a couple of years ago and has been going through various rounds of amending and regulations, but it gives a right of erasure of contributed data. And here's what it says: a consumer shall have the right to request that a business delete any personal information about the consumer which the business has collected from the consumer. In other words, when you log on to a website, let's say Amazon, and you type in your name and your phone number and your address, and you decide you want to get off Amazon, Amazon has to have the ability, if they're doing business in California, to erase that data if you want to be off their platform. It doesn't pertain to publicly available data that they collect elsewhere or data contributed by a third party. And it also includes exceptions for the exercise of free speech, ensuring the rights of other consumers to exercise their rights of free speech or other rights provided by law. So it's unclear now with this new law what it exactly is going to do in terms of restrictions, but basically it's if you contribute your own personal data, you get the right to erase it. But you might want to question how is that going to affect if you contribute data about another person? Do you have the right to erase that? Probably not, is what I would say under the new California law. But again, it's new, and so we don't really have much to go on. We do have other restrictions on the availability of records in the United States. For example, by consensus, census records are sealed for 72 years. I don't actually think there's a law on that, but it's just sort of what they do, and no one's challenged it. But these restrictions all pertain to access to public records and not at all to online family trees or other data published by individuals. So it's a whole different topic what public records are going to be available. There's a tendency in various jurisdictions of the United States to limit access to birth records and marriage records and things like that, which of course concerns us as genealogists as well. But in Europe, the main focus, the right of erasure, seems to be on erasing true facts that are embarrassing to people. So like you filed for bankruptcy or you were accused of a crime. That's the same type of thing that led to the right to privacy in the United States 80 years ago. It seems to be they're allowing erasure of those type of things, but so far I haven't heard of any effect on a family tree. There is, I'm gonna skip ahead so we can have more time for the questioning. How are we doing? Oh, it's 12:30. Okay, so we have about a half hour left. I would say we may be heading, we're not there yet, but we may be heading to a legal regime where publication of Jewish genealogical data is permitted in the United States, but prohibited or at least potentially restricted in Europe. In Europe, there's still a lot of people who want to sort of hide their Jewish background, and that that dovetails into the interest of anti-Semites to erase the existence of Jews in history. And so they pass laws sometimes limiting the ability to publish information that people have Jewish backgrounds or lists of Holocaust victims and things like that. So we have to watch that. But in America, I don't think those things are ever going to be limited. The right to be forgotten and right of erasure emerging in Europe, I think, extends far beyond the right against public disclosure of private facts as developed in American law, based as they are on the subjective desires of the individual and not the reasonable objections of an ordinary person. Take, for example, that recent case in the Netherlands where the daughter didn't want her mother to post a picture of the grandchild on Facebook, right? So a reasonable, ordinary person wouldn't care, but they're very solicitous of the individual, the very sensitive individual demands in Europe, not so in the United States. If so far, at least, I think there are no restrictions on the publication of genealogical data in the United States or Europe. And we're just gonna have to watch the cases as they develop in Europe and see how they affect us here in the United States. I'm going to turn now, though, to the corporate response to all of this. Multinational corporations who do business in both the US and Europe have faced now a dilemma on how to react to the increasing demands for online privacy. Google and Facebook, of course, are at the forefront of this battle, but they're not alone. Genealogy sites such as Ancestry and MyHeritage, which owns Genie, also have to tread carefully through this changing legal landscape. But as I'll demonstrate, the leading online genealogy providers have established rules protecting privacy even beyond what is required under American or European law as a result of purely market considerations. I think I have some examples here, if I can get to that. Oops, not letting me click. Whoops, DNA, I didn't talk about DNA yet. There's Ancestry. On Ancestry, which allows users to build individual family trees, the default setting is public for deceased profiles, which means that other subscribers can view all the content in the tree except information about living people and notes. There are two additional levels of privacy on Ancestry that one can select to make the tree more private. Trees designated private cannot be viewed by other subscribers, but limited information about deceased individuals in the tree, such as the name, birth year, and birthplace, will appear in search results within Ancestry.com sites. For added privacy, one can prevent the entire tree from being indexed and found in searches. The tree owner can invite others to share the tree and also decide whether to allow invited members to see living people or just the deceased people. Public trees on Ancestry may be searchable via Google and viewed by non-subscribers on what they call the historical person searches pages that Ancestry allows Google to index as part of its marketing and promotional activities. However, as far as I can tell, there's no way to guarantee that your Ancestry tree will be discoverable in a Google search. MyHeritage protects privacy in much the same way as Ancestry. Its privacy policy states, we recognize the sensitivity and confidentiality of information that may be disclosed by users in registering, making purchases from our website, or performing family history research, and we are firmly committed to protecting privacy. Each tree has a webmaster and site manager who can invite others to join the tree as members or guests. Living profiles have their first names, dates of birth, gender, and photos hidden unless the user has been given access to the tree as a member. However, unlike Ancestry, on MyHeritage, users without access rights can still see the last name of a living person on the tree. Users have a host of privacy options regarding access and content, including whether to allow people to find the tree or request membership, include the tree in MyHeritage search engine, enable smart matching with other trees on MyHeritage or its partners like Genie, and whether guests can view the tree or search, view, or copy photos. Like Ancestry, information from public profiles on MyHeritage may or may not appear in Google searches as a result of the company's marketing efforts. Genie has a little bit of a different aspect to it. It operates an online collaborative tree that requires somewhat different rules. Genie's World Family Tree has, I think, over 140 million connected profiles with over 4 million users, all working together on the same tree. On Genie, profiles are divided into two groups, public and private. In general, living people are private and deceased are public. Genie will permit users to make even deceased profiles private, but they may be made public again by other users or curators, especially if the person in question was born more than 150 years ago. Celebrities and other public figures who have been designated as master profiles by one of the Genie volunteer curators are also public, right? So here you can see Benjamin Netanyahu's profile is public. A user can make his or her own profile public as well. If you go back to my tree, you see an example of my wife and siblings, etc., are all visible because they've made themselves public. Profiles that are marked living, but which are presumed deceased because the birth date is several hundred years ago, are also made public. Private profiles can be viewed by people inside the family group of the profile, which is defined as fourth cousin or less. So you can't hide from your fourth cousins. Additionally, curators and anyone who has been added into the family group of a manager of the profile can view and edit the manager's private profiles. Genie's volunteer curators sign non-disclosure agreements and agree to keep private information confidential, but they're given access so they can assist users and resolve issues in the trees. In contrast with Ancestry and MyHeritage, public profiles on Genie are fully indexed and searchable on Google, and Genie's search engine optimization is quite good, so the profiles often appear high on Google search results. Genie allows a limited right of erasure, such that individuals may request deletion of their own profiles and those of their surrounding immediate relatives, subject, of course, to the possibility that someone else will just add them back to the tree. I described the policies of Ancestry, MyHeritage, and Genie from the perspective of those who want privacy. But what about those who want to publish their trees and are not concerned with privacy? Because of the privacy restrictions imposed by the various companies, there is no collaborative online platform where you can publish your tree openly without restrictions. The only option for a public family tree is to have your own website. Programs such as Reunion or Family Tree Maker will build web-based trees that you can upload to your own website. People who want a public tree frequently use this option. As I've demonstrated, companies such as Ancestry, MyHeritage, and Genie have developed privacy standards not as a result of legal requirements, but as a marketing strategy. Again, there is no law in the United States or Europe that requires any portion of a family tree to be private, or that prohibits anyone from placing a fully public family tree, including living people and minors, on the internet. Not only are there no laws restricting online family trees, but the online companies are protected in the United States from any possible liability as a result of internet safe harbor rules, which prohibit lawsuits against providers of online forums for users who post their own data. The limited number of European cases on the right of erasure so far concern deletion of links to embarrassing criminal and debt-related items from search engines, somewhat in line with early common law cases that I discussed earlier. But to my knowledge, there's not been any case brought in the United States or Europe concerning an online family tree, nor could there be under the existing legal regime. Let me talk a little bit about DNA. I don't deal as much in this lecture with DNA because it's, again, sort of an evolving area. I would say that DNA, my 3 points are: if you test DNA, be prepared for surprises. I have a friend, for example, who came to me and said he did a DNA test with one of the companies, came up with a close hit, and it turned out, he thinks, that one of his sons had contributed to a sperm bank, and the resulting child was tested by the kid's mother, and so my friend found out he was a grandfather. None of his sons had given him any other kids yet. So the question was, does he tell anybody? Does he tell his ex-wife that she's a grandmother, etc.? Who knows? There's no rule on how to deal with these cases yet. You also will hear in the news a lot of discussion about law enforcement use of DNA. There are now TV shows about this, and it's really sort of unavoidable. I had someone tell me, no, didn't want to take a DNA test because someone might find him. And my answer was, well, someone's going to find you anyway because probably someone else in your family is going to take a test. And then there was a lot of discussion a while back when Family Tree DNA, which is one of the big DNA companies, agreed to allow the FBI to use their database to conduct these type of investigations. It's an evolving field, and in general, we're finding out you may have privacy in your own DNA, but to the extent that you that you match the DNA in some of your relatives, you won't be able to hide that. So I think we'll have to all be aware of that. The internet, I think, has greatly changed our notion of what is private and what is public, and has changed our notion of what it means to publish things. Access to information has exploded. What formerly was known and available to a small circle of local friends and neighbors is now only accessible to the entire world, about 8 billion people. Many people are still adjusting to this new reality. The more paranoid and narcissistic among us have become, I think, even more so. There's a tendency, I think, for all of us to want to believe that everyone else in the world thinks we are as interesting and important as we are to ourselves. But that is obviously not true. And there's a good reason not to become too carried away. It used to be that when the government collected information about a person, it meant that someone somewhere had identified and targeted him or her for surveillance. We established safeguards against unreasonable, warrantless searches to prevent abuse of that power. But we shouldn't pretend that our concerns should be the same when the government engages in mass, untargeted data collections. Alarmists and companies selling security products, which is a huge billion-dollar business, have preyed on our natural narcissistic paranoia and our inability to comprehend large numbers to stir up demand for greater privacy protections. I think this is what's driving the laws that we're seeing, not any actual need, but just sort of a psychological need that people have to feel like they're being protected. The truth is, I think that no one really cares about any of the things that we are trying to hide. 8 billion people might have access to your birth date or your mother's maiden name, but it's still just you and your neighbors and your friends and relatives, the people who already know you and are connected to you, who will ever look for you and find you online. It's time to start thinking, this is my opinion, about what it is we are doing when we give people the right to erase and hide facts about their lives and prevent other people from finding them. Scientific inquiry, freedom of thought and expression, artistic freedom, the ability to analyze history and discuss issues of public concern, all of these are human rights as well. For genealogists, especially those of us like me who are committed to the idea of building a world family tree, it's time that we spoke up and defended our own rights and interests. Outside of the publication of objectionable private facts, there really is no such thing as a privacy in the context of a family tree, nor should there be. Thank you very much for listening. I am now finished with the presentation. I still can't see myself, and Avrami, you're a blank screen. But here's the summary of what I've presented so far. Deceased individuals don't have a right to privacy. There's really no legal limitation on publishing genealogical data, which is really presumed to be public. And since that information is not objectionable to a reasonable person, living individuals may have a right against public disclosure of private facts that would be offensive or objectionable to a reasonable person of ordinary sensibilities. And then I have the points about online genealogy sites. Their rules are really governed by market factors and nothing more. Okay, so that should answer sort of the general question is, subject to the rule against public disclosure of objectionable private facts, genealogists are generally free to publish online family trees and don't need to accede to privacy requests from individuals named on those trees. Now, we had a lot of questions that were asked, and a lot of them have to do with not so much the legal rules, but sort of the ethical rules, or what should we do as genealogists. That I put under a different category of sort of, in Hebrew you would say shalom bayit, right, the peace at home. So if you have a relative or cousin that's asking you not to put them on the family tree or not to put their wife on the family tree, you might agree to do that because that's the way you keep peace in your home, in your family, not to upset people. But you should know that you're not legally required to remove anybody from your family tree. I think that's important to know. So Avrami, if you're still there, I'm going to go to the questions now, and I typed them out.
Okay.
So people can, and I've taken the questions that people have submitted, and sometimes I've edited them a little bit to make them shorter. But anyway, I don't think anybody will be identified or upset with that, I hope. So one of the first questions I got, and it's a common one, is someone took my error-filled tree and copied it and submitted it to JewishGen. How can I fix that? In other words, someone had a tree that they were working on, had lots of mistakes in it that hadn't been fixed. Someone has just taken that and submitted it, presumably to Family Tree of the Jewish People. Avrami's probably better to answer that, but for all the companies like JewishGen, like Ancestry, like MyHeritage, like Beit Hatfutzot did it in Israel, that collect people's individually submitted family trees, you're going to find lots of error-filled trees. That's just the way it is. Mistakes are unavoidable in genealogy. There's no such thing as being certain about any fact. And so you're going to have that issue. As far as I know, there's no way to correct another person's tree on JewishGen or any of these other platforms. The only place that that's possible is on Genie or Wikitree, or which is much smaller than Genie, or Family Search. They also have a public tree where people work collaboratively and you can fix someone else's mistakes. And that's why it's a whole other lecture, but that's why I think those collaborative trees are really becoming the sort of go-to places where you can find correct information rather than the individual trees that people have submitted to these various places like JewishGen. Second question, I have my tree and DNA on Ancestry. When a DNA match asks me to share my tree, should I accept? This again goes under the rubric of when you do your DNA, expect to find surprises, right? You never know what you're going to find. So should you share your tree? I would. I don't have anything to hide. If you have something to hide, don't share your tree. If you do not have anything to hide, then feel free to share it. DNA results, as most of us who have done DNA on Ancestry or Family Tree DNA or MyHeritage or 23andMe know, you get a lot of potential cousin matches because of all the endogamy in the Jewish community. Everybody looks like a third cousin or fourth cousin. In reality, everybody's a 12th cousin. But you're unlikely, therefore, to find a link to most of the people who match you in the DNA, but it doesn't hurt to share, and a lot of these companies will allow you to share genealogy information that way. So I would, but it's really up to you. Third question, are invited members of your tree allowed to tell you not to put someone else's photo on your tree? So the answer is they're allowed to tell you that, but you're not required to listen. If it's your tree, and you know, I always tell people when they try to tell me what to do, I say, you know, I don't go around telling you what to do, and you probably shouldn't go around telling me what to do. If you have someone you want to put on your tree and someone else doesn't want it, that's going to be up to you whether you want to keep peace with that person or upset them. The photo issue can be a little different because it dovetails into copyright. People don't understand copyright, so often they're very upset. They have a picture and they've shared it with someone and that person has copied it and they say that's not allowed. It might not be allowed, but the person who shared it also may not have the right to do it and right to complain about it because the owner of the copyright is the photographer who took the picture. And so you would have to find the photographer. The photographer could object. And so I've had instances where people say, no, don't put that photo that I took on your family tree, and so I accede to those requests. But if someone just has an old family photo that they don't own the copyright of and may be in public domain, you really don't have to listen to them when they tell you to get it off your tree. What are the consequences of differences in privacy rules in countries such as Germany, Canada, and the UK? Okay, that's a great question. I'm not the world's expert on all the world privacy rights. I did try to talk about European Union a little bit, but each locality is going to have a different rule, and you have to be very sensitive to that. The companies that operate in all these different territories also have to sometimes be sensitive to that, and there are complicated rules of jurisdiction in different locations on who can get sued and why and where. And so it really ranges. If you have an international company like Ancestry or MyHeritage, you have to be aware of all these issues and come up for rules with dealing with them. In terms of individuals, you really should only worry mostly about the law in the place where you are, right? So if you live in a jurisdiction that says, no, you can't do that, then you have to maybe not do that, right? But if you're living in a place that allows it and someone says, well, back in my home country, that's illegal, you say, okay, that may be true, but I'm not there. And so you don't have a right to tell me what to do since I'm not there. But that has to do with legal jurisdiction issues. And in general, you're not subject to a jurisdiction unless you've done something to sort of inject yourself into that jurisdiction, like go there or send something there. Okay, next question. I was asked by my second cousin not to include her or her mother who has passed in my tree, but both of them are important to me. What are my legal rights? So I think I explained that legally you are well within your right to put these people on your family tree. They're in your family, you know them. They don't have a right to tell you what to do. You don't tell them what to do. That's the law. Whether you want to do that, again, is going to come down to sort of the ethical concern of how much do you want to upset your second cousin. And really that's the rule. It's not a legal issue. Sixth question, can genealogy companies such as Ancestry hold on to information not allow you to download it to your computer? I have no idea what the download rules are right now on Ancestry. I know on Genie you can download a GEDCOM file that's, I think, up to 4 times the number of profiles you've added to the tree. Each company has different rules. Probably it's governed by their terms of service, which give them certain rights to the information that you contribute to their database. Again, this is, maybe subject to the new California rule that you can erase yourself. But I'm not quite sure how to answer this particular question. And I'm not sure that Ancestry doesn't allow you to download it to your computer. I think they did, or at least they used to. Okay, 7. How can we reconcile the needs of genealogists with families' needs for privacy in a sensitive way? So again, this is not the legal question. This is the sort of ethical question, what type of person you want to be. It's hard. It's hard because I think a lot of people are increasingly, as I said in my paper, sort of paranoid. There's a billion-dollar industry that feeds our natural paranoia, tells us that everybody's out to get us so that we can buy products. We've all heard them on TV and radio being advertised. You buy this to protect yourself from whatever, them out there. And so a lot of people feel that way. They feel they need that protection, even though there's absolutely no danger, as I've said, from a family tree. So you have to be sensitive to their concerns if you want to be. If you don't want to be sensitive to someone else's concerns, you don't have to be. I think that's the rule. Are the rules of privacy different for living than from the dead people? We did answer that. Yes, very much so. Dead people in general do not have any privacy rights, and their living heirs generally can't enforce any rights that they might have had while they're alive. So yes, the rules are different for dead people. What should we do if a relative does not want it known that an ancestor was a horse thief or insane or an unwed mother? This, I think I talked about it again. If it is a living person, you have to be careful about disclosing private, objectionable facts that a reasonable person wouldn't want known. But for deceased relatives, really it's up to you how much you want to disclose on your family tree. There's no legal requirement that you not disclose information about deceased people. 10, what is my opinion on using a person's social media post to help build the tree? That's a good question. So this person had said they often go to Facebook and things like that to find other relatives, and then they feel a little awkward. Is that like stalking the person? Can they use that to build your tree? And I think the answer is, I think it's fair game. We all have to get used to the idea, again, that we live in a community, and no, I like to quote John Donne, right? No man is an island. We all live with other people and share information with other people all the time, unless you're living as a recluse. And so people who post on social media, I think, need to understand that other people are going to see it and they're going to get information from that. And that's okay. When we walk out on the street, people can see what we're wearing, what our hair looks like, all those other things, and it's no different online. So I think you can and in some cases should use social media if you want to really find out about people on your family tree. Be prepared for other people being upset about it, but you have a right to do that. Okay, 11, here it is. Writing a family history book with biographies, and this person wants to contact the people to see if they have any information to add or if things are correct, but is worried that what if someone says they don't want to be included? Again, this comes under the rubric of how much do you care what they think. I think every author, almost all famous authors, mine their own families for stories that they use in their books, and I'm sure it upsets if any of you have family members who are writers, you know that, right? So it's you can write about other people, you can talk about other people. There's no law saying you can't tell a story about another person. If they don't want to be included, it's really up to you whether you accede to their request or not. Again, with this small exception of very embarrassing private facts that most people would find objectionable. 12, someone completely unrelated has added to my tree and messed things up. What can I do? So this would be, if it was on Ancestry or MyHeritage, it would be you invited the person to your tree and they messed it up, in which case you probably can kick them out and clean it up. If it's a collaborative tree like Genie, then you have to work together. That's one of Genie's, I always say it's not for people who who don't play well in the sandbox with other people, you got to get along with everybody else, otherwise it doesn't work. So a lot of people can't handle that, and they go off and have their private trees on MyHeritage and Ancestry, and that way you can keep everything under your control. I find it much better to collaborate, and so that's why I work on Genie. If something is messed up and you can't resolve it with the other person, on Genie we have volunteer curators. I'm one of several hundred of them. You just have to ask a curator for assistance, and the curators will come up with solutions, usually that can satisfy everybody. Does someone have any legal right to ask for the removal of photos simply because he wasn't asked in the first place about their inclusion? This again, if you are a photographer and you have a copyright, you can prohibit the copying of your photos. So the answer is yes, the copyright holder, who is the photographer. But 99 times out of 100, the people asking for removal of photos are not actually the copyright holders, and they don't have any right to ask you to remove the photos, but the copyright holder would. So you have to know, the question you could ask is, did you take the photo? Or did someone take, do you have the rights of the person who took the photo? And if the answer is no, then you don't have to answer. But if the answer is yes, then you do. Okay, let's see if I can get to the next page. There it is, I think. Did I skip a page? There it is. In light of Jewish genealogy groups expanding their efforts on Facebook, such as Jewish Genealogy Portal, which I think, as Abrami said, I helped found, and which works with JewishGen now on Facebook. How do we deal with the fact that Facebook is notorious for using and selling all the data collected on their platform? This, again, I think falls under the category of people who are, I think, in my view, overly concerned about privacy issues. Facebook, yes, is notorious for using and selling data, but not in the way that you think. I apologize to the hundreds of people who are listening, but the best example I can come up with is everybody in the world farts several times a day. We generally aren't concerned with where that gas goes. If there was someone who figured out a way to collect all of those and collect the methane and then sell it, would we be offended, right? Would we be upset? That's what Facebook does. Facebook aggregates millions and millions of tiny worthless pieces of data and does use that as a business. But it's not information that, it's not like your personal information has any intrinsic value itself. It's only aggregated that has a value. So I think there's a certain sense of sort of, they're making money off me, which really doesn't make sense so much. So anyway, Facebook does have a business operation, and they do sell advertisements based on the things that you post, and that's allows us then to use the platform for free for other things like the Jewish Genealogy Portal. So I personally don't see a problem with it. I think that people who are not on Facebook have other avenues like the JewishGen discussion group, where you can get a lot of good responses and information. It's just a question of where you want to be and how many people you want to reach. I think this is the last question. Is there, at least the ones that came before the talk, is there a way to initiate contact with a distant relative without seeming intrusive or violative of the other person's privacy? Are there some circumstances where it would be acceptable and safe to do so and others where it would not? This, again, is, I think, not going to be a legal issue, but more a feel for how the person might react. And that might depend on how you found the person, how closely they are related, etc. But it's obviously a good question. A lot of us do genealogy and we find our fourth, fifth, sixth cousins, and some of them want to be found and some of them don't. And I think as a genealogist, you maybe have to develop a thick skin and get used to some people not being happy with what you do, while knowing at the same time that you're happy with what you're doing and that many other people in your family are as well. Anyway, I think that brings me to the end of those questions. Avrami, are we finished, or do you want me to do something more?
Thank you, Randy. No, we're going to wrap it up. There were a number of questions posted, but you've actually covered nearly all of them, both in the presentation and also in these questions that you just went through now. Randy, I'd like to thank you. This was a very comprehensive and interesting presentation, and I think it has given everybody a lot to think about. Just want to mention that for anybody who'd like to listen to this presentation again, you could go on our Facebook page, facebook.com/JewishGen.org, and you can access the recording. It will also be on our YouTube channel within 10 days. And I also encourage you to participate in future JewishGen talks. You can visit JewishGen.org/live, Next week's presentation will be given by Karen Franklin, and her topic is Rescue and Resettlement, Researching Refugees from Nazi Europe, and that will be presented in partnership with the Leo Baeck Institute and the Jewish Genealogical Society of New York. I encourage all of you to please register, and that will be a very informative and meaningful presentation as well. So Randy, thank you very much again
Thank
for
you.
participating, and wishing everybody a wonderful day.
Thank you. Thank you, everybody, for attending. And you can always find me on Facebook or Genie, or just Google my name and you'll find me. You can contact me, and I love getting in touch with people and answering questions. Thanks so much.
Take care.
Bye. Okay. Success.